Strings.
Yes.
Much obliged. We address the bench as sir.
Yes.
Much obliged, sir. Sir, I am speaker 1, representing my client Som Rajendran, and will be dealing with issues first and second. And my co-counsel will be dealing with issues third, fourth, and fifth. Sir, the council has clubbed two issues.
You see, you have to conclude.
Clubbed the two issues from proposition, that are the first and sixth issue. Sir, if the bench is not well versed with the facts, council wants to proceed with the facts of present case. Sir, Happy Babies Hospital introduced a gamma sound test for detecting congenital heart disease, offered standalone or as a part of stock package. Som Rajendran and Uma Rajendran mistakenly purchased the costly stock package due to BIPL's misleading website design, hidden pricing, customer service, and also customer service failed to resolve the issue. The hospital lacked basic amenities, including hygienic food, and there were complications during Uma's pregnancy. Their daughter, despite normal test results, was born with an enlarged heart and died a month later. Also, Uma suffered a permanent reproductive damage. So, BIPL website featured checkboxes, falsified reviews, and unsafe equipment that endangered waste handlers. So, the complainant had filed the complaint under Section 47 of Consumer Protection Act 2019 against BIPL and BIP Suites for deficiency in service, misleading advertisements, dark pattern, and greenwashing. So, council now seeks permission to proceed with the first issue, that hospital constitute deficiency in service on their part, and there was no contributory negligence on the part of consumer. Much obliged, sir. So, there was deficiency in the part of hospital because of many reasons. So, firstly, could you please refer to memo's paragraph number 4, the Moot memo? Who acquires goods or uses a service by paying fully, partially, or on deferred payment basis. Sir, the services was taken for a valid consideration of 2,50,000 rupees. Sir, the props, if you could refer to paragraph number 12 of Moot proposition, the 4th line, the 5th line. He realized that he would be spending rupees 2,40,000 over the next 1 year. Sir, he was paying rupees 2,40,000 for like a consideration, and the consideration was paid. The services was not taken free of cost and not for commercial purposes. Sir, if you could refer to compendiums page number 2, the Indian Medical Association versus VP Shanta case. So it is clearly stated that the highlighted part, amenability of services rendered by medical professional and hospital under Act of 1986. All kinds of services rendered by medical practitioner, except where such services are rendered free of charges to all and under contract of personal service comes under term service under this Act. Sir, therefore my client uses services like gamma sound test, and the services was included.
Have they raised this point that it is not maintainable? That
you
you are not a consumer, it is not a service. Has the other side raised?
The defendant.
Yes.
Have they raised that?
Indeed, sir. They have raised that there is no jurisdiction of having, like we don't have any jurisdiction to approach the court.
But on what grounds have you seen that?
Indeed, sir. They stated that the claim amount is not 50 lakh rupees.
That is a different point. It's a pecuniary jurisdiction point, not on jurisdictional facts. So why are you addressing
No,
that?
raising whether this court has got jurisdiction or some other forum has jurisdiction.
No, the question of whether he is a consumer or not.
Sir, I am
Where
just
is that
stating that whether
No, but
whether I
have they raised that point? Is this in dispute?
So the council is still not aware of the fact because of the delay, because of the proposition exchange.
No.
No, from the proposition or somewhere else, do you see there is towards the end of the proposition, there is a brief paragraph on what the main contentions of the opposite party is.
Indeed, sir.
So from this, do you find that that is one of the issues, or in the issues that arise, is that named as one of the issues, whether this is a consumer or not?
So this was very basic, that the opposite party would raise some such issue of consumer, and that's why the complainant raised the issues. So if the bench is now satisfied with the arguments above, council seeks permission to prove that there was deficiency in service on the part of hospital and no contributory negligence on the part of consumers. So deficiency is defined as any fault, imperfection, shortcoming or inadequacy in quality, nature or manner of performance required by law or agreed upon in a contract concerning a service. It includes acts of negligence or omission which causes loss of injury to consumer and deliberate withholding of relevant information by such person to the consumer. So the basic principle relating to medical negligence is stated in the case of Bolam, Jacob Matthew versus State of Punjab, the Bolam rule. So it has been approved that
Golden rule from which country?
Bolam rule is from France, Fried and
France.
something.
So what is the basic of what basic proposition was laid down in this case?
In the Fried management.
Yes, Bolam case.
Uh,
Because that is being followed till now.
Indeed, sir. In the Bolam case, it was stated that there must be a duty of care owed towards patient. Secondly, there must be a breach in that duty, and thirdly, because of that breach, the complainant must suffer some harm. So these were the principles stated to define medical negligence. That is there any medical negligence on the part of hospital? Sir, wrong diagnosis is considered as medical negligence, and when someone goes to hospital, the first and most basic step is diagnosis. So the council requests the bench to please refer compendium page number 13. So the case of Sahiba Hamid versus Dr. D.M. Khan Hospital, 57th paragraph, the highlighted portion. So some of the common categories of medical negligence are as follows. Wrong diagnosis. When someone goes to hospital, clinic or medical room, etc., the first step after admittance is the diagnosis. Diagnostic symptoms correctly is critical and important to provide medical
What was the
care.
wrong diagnosis?
In the case of Sahiba Hamid,
In this case,
in this case, the diagnosis of congenital heart disease, which they claimed of accurately predicting the heart disease, but they failed in predicting the heart disease, and they clearly stated in the moot proposition, paragraph number 4.
You see, be very brief. What is the wrong deficiency? You are quoting deficiency. What is the deficiency? You are saying in conducting the gamma test.
Yes, so they were deficient in conducting the gamma test because they failed.
How deficient?
Because sir,
is
it is stated that it is the hospital's responsibility to conduct a diagnosis properly, and it is upheld in the case of Sahiba Hamid that
Sahiba Hamid, V. Santa Medical, and Jacob Matthew. You are concluding.
indeed sir, the paragraph number 4, it states that the test uses accurately. So the second line, with ultrasound to accurately diagnose and forecast possibility of fetus developing congenital heart disease. This was their contention, that they accurately diagnose. And secondly, sir, they stated that there is no chance of having any congenital heart disease in the baby, and still the baby had congenital heart disease, and this was the deficiency on the part of hospital.
You mean to say their conducting the test was improper, it was filled with shortcomings, because on the one side you are saying it is full of accuracy, result is full accurate, but the very next day when the result comes out, the baby is found with enlarged heart.
Indeed, sir, they just
This you want to say was a kind of deficiency?
Yes, this was deficiency. The claim which they made, they can't fulfill the claim, and this is the deficiency on their part.
yeah, what if you had come to know what was the cure at that point of time? If you had come to know that the baby is suffering from congenital heart disease?
So there could have been many cures when if the congenital heart disease, the almost 3 months were there when the test was
I
conducted.
don't find anything that what corrective action could have been taken which you could not take because of the wrong diagnosis.
So in the fetus only, there could have been possibilities that some medical.
Possibility, is there
So the moot proposition is silent on the fact that there are any kind of such things, but it can be possible in
Yes.
the fetus.
In the proposition there is no mention whether your hospital was providing any facility for operating the child, for making any good treatment to save her life. There is no mention in the facts.
So it is mentioned that they accurately predict the
Yes,
disease.
means only for test.
Sir,
They are conducting just test. They can predict which child laddu hai, pela hai, what kind of child they are going to give.
so this was the one point on which they were deficient in, and there are many other subsequent points coming up in the arguments.
My friend is asking about what kind of deficiency was there in treatment. Was where your hospital was your hospital providing any facility for treatment of the child?
Indeed, sir. The complainant bought the stock package, which include all other usual tests and delivery of the baby. This was all included in the package, and it was like whole prenatal care package. And that's why, sir, it was their duty of assuring everything. It was a full package of stock. And sir, deficiency in diagnosis is the core part. This is the core part of the complaint. Sir, is the bench with the council? Can we proceed?
You have to proceed.
Okay, sir. Sir, the hospital responsibility is not limited to treatment, but it extends to overall well-being of patients on its premises. And they should have maintained a reasonable standard of care, not allowing any random tea shop in their premises to operate, whether or not it was under their control. They had to maintain the safety in their premises, and because of no proper canteen facilities and having the tea shop food, my client suffered food poisoning. So it is clearly stated in the props paragraph number 17.
Why have you referred to the Environment Protection Act in this statute?
The environment claims that they made of low doses, like low doses.
What is the purpose of an environment protection?
The purpose of Environment Protection Act is to sustain the environment.
Why have you referred? I am not able to understand.
So the environment protection,
What is the violation of the Environment Protection? That's the last question I'm asking. What is the violation of the Environment Protection Act you are alleging, or is there any violation?
So yes, there was violation because of the greenwashing that they did. They stated that they used low doses of gamma radiation, but the compendium.
So what compliance was not there?
So they.
Under the Environment Protection Act, what were they supposed to do, which they did not do?
So they were not supposed to make such claims of like greenwashing claims.
That Environment Protection Act.
Sir, this issue will be dealt by co-counsel in the further arguments also.
2 minutes more.
Indeed, sir. Bench is having no questions. Can I now proceed that hospital website was engaged in dark patterns? Much obliged, sir. So it is humbly submitted that there are many dark patterns observed in the reported user experience on the hospital website. According to guidelines of Central Consumer Protection Authority, basket sneaking is inclusion of additional and unwarranted product or payment without the consent of consumer. Sir, there was a checkbox in the website, and it was like we have to check it to not purchase the stock package. It was used like vice versa. It could have been that I want the stock package checkbox, but it was like I do not want the stock package checkbox, and we have to click the checkbox if we don't want to buy that package. So
that might be an oversight on your part.
So they just use this tactic of dark pattern as.
No, how is it? They have given you an option, you have missed it. That may be a negligence or oversight on your part.
Sir, could you please refer to compendiums page 66? So the basket sneaking, the guidelines have been attached. The basket sneaking is addition of paid ancillary services with a pre-ticked box or otherwise to the cart when a consumer is purchasing. Pre-ticked box or otherwise.
It's
like
not pre-ticked.
Pre-ticked or otherwise, not a pre-ticked box or
how?
It's an opt-in versus opt-out model.
Ah,
So how are you saying that is a dark pattern?
They just stated that pre-tick, the guidelines is stating pre-tick box or otherwise, which means pre-tick or not pre-tick box.
How then?
So
that
that
is interpretation. Either it's pre-ticked or not pre-ticked. So everything will not be covered under the dark pattern. My question to you is, why can't someone assume that it was your negligence, your oversight that you did not read it properly?
So firstly, to answer your question, there was no point of having. Sir, can I just
answer this question?
Indeed, sir. So there was no point of adding a checkbox. Like he just wanted to tell. They advertised the gamma sound test. They just independently advertised the test, and they deceptively just added a checkbox so that the consumer, if even they wanted to purchase only the independent. Secondly,
purchasing is the procurement process.
Secondly, they also use many other dark patterns like false urgency. Only three slots are remaining for August, and many other dark patterns like cancellation trap. So because of that, the consumer made the hurry that they were using dark pattern that only 3 slots are left. So consumer was in hurry and they just put the checkbox. So this was all like website interfaces. So sir, this was all the dark patterns, and my co-counsel will now proceed further for third, fourth and fifth issues.
Okay.
Much obliged, sir.
Dice. Much obliged, sir. Greetings to the honorable bench. If sir has no query regarding the submission made by my co-counsel, the counsel seeks permission to proceed further. Much obliged, sir. So proceeding with the third issue, it is humbly submitted that VIP Suites and VIPL are not separate legal entity and should be considered as same legal entities. Sir, in the Vodafone International Holding BV versus Union of India, it was said that there is a well-settled principle that a holding company and subsidiary company should be treated as separate legal entity.
That was for the
However,
purpose of
sir,
tax.
sir,
That was for the purpose of taxation.
Taxation and company affairs. Could
sir,
it be related to this consumer forum? Because
If they are the same entity, then how it is the case of surrogate advertising? What is the definition? Just have a look.
so the main two essential
Just tell me the definition, sir.
surrogate advertisement is defined in the section 2H of the guidelines of the prevention of misleading advertisements.
Read it out.
And it is said that the main essential that it should be firstly the legally prohibited goods. Secondly, the advertisements should be of the similar restrictions, that restrictions should not be put on that, but there is another advertisements who is portraying that these advertisements, like your Kingfisher company does that. They are alcohol industries, it is prohibited under the law to use these alcohols advertisements, but they have used the surrogate advertisements by using these another companies and like soda companies and all.
In those cases, the same company is advertising. Suppose a sports is advertising. There are two different entities in law,
So
and it is not a dispute that the second company does manufacture sweets.
So, answering to your query, the second company, firstly, we are contending that it is the same entity because it is purposing for surrogate advertisements. If we look closely to the advertisements of VIP Suites, they are portraying that baby boy is Peda as baby boy because it is wearing shorts and ties, and baby girl was amorphized as.
If the advertisement was so good, you would have known beforehand that this is the purpose of the advertisement, but you only came to know as per the brief after the PIDA was handed over.
Sir,
Get my point?
yes sir.
You were not influenced by the surrogate advertisement.
Indeed, sir. Sir, in the paragraph
And if you
number.
were not, then how are you alleging? That's what I want to know. Only after the PIDA is given, you understand that this may be a surrogate advertisement. So the advertisement was not the reason that you came to. You were conscious that you did not want a determination of the child's sex.
Indeed, sir.
You did not come there.
No, sir. We come for the congenital heart disease detection. But, sir, in the paragraph number 15 of the moot preposition, it is said that a person who seems from the hospital administration.
Talk about yourself personally. It's not a public interest thing. It's about you.
Yes, sir.
And second question is, I have to ask both of you. If the CCPA was in session of the matter, why did you approach the commission?
Sir,
What are the options? What were the options before you? Couldn't you have pursued the matter before the CCPA?
sir, we approached here
You did not approach the CCPA.
even there you could have gone to the authority under 10 CCPA.
Huh?
Why you are
Why did the complaint come here? They could have approached the CCPA.
So, answering to your query, we are here under the section 47 clause.
That's what I'm asking. Why did you file section 47? Why didn't you go before the CCPA under section 18 of the consumer?
Even CCPA, it goes to CCPA based on your initial complaint. So have you not made two complaints out of one in this case?
So we went for the complaint of divisional executive magistrate, which is we followed a proper procedure that first we have to go for divisional executive magistrate. They ordered the investigation wing related to the CCPA. The investigation wing proceeded this all the arguments or all the contentions that were made by us, and they even contended that our
Why did you
findings.
take it forward? That's what I'm saying. Why did you leave it there?
So we wanted to take the compensation for our loss. That's why we are here.
You don't want the advertisement to be banned.
So,
You want your compensation. That's
so
what.
we want the advertisements to be banned as well and the compensation as well.
so whether the Consumer Commission has got power to ban it, to desist, to direct to desist it from making any surrogate advertisement or any such kind of advertisement?
Yes, sir, because it is it is violating comes under the ambit of misleading advertisements, and it is violating the Consumer Protection Act as well.
Which
So,
provision?
the commission, whether the Consumer Protection Act gives power to the commission state forum or district forum to prohibit such kind of leading, misleading or surrogate kind of advertisement?
So the State Commission have the power to adjudicate the matters of misleading advertisement under the Consumer Protection Act, and it was in section 47 of the stated that there is a jurisdiction for the State Commission to address these matters. Firstly, that VIP suite is a sham entity which is created to defraud the consumers. Secondly, the work of VIP suites and VIPL is working against the public policies. So it is a defrauding the consumers because under section 447 of the Companies Act, it is defined that companies, firstly, that there should be an act, omission or concealment. Secondly, there should be an abuse of possession. Thirdly, there should be an intention to deceive and gain undue advantages. This will constitute a fraud in our case. In our case, sir, the VIPL abused possession and they created a subsidiary company that is VIP Suites. And their advertisements of VIP Suites said that, so the council requests the bench to please refer the moot proposition paragraph number 6.
But is VIP Suites a party?
So it's an ex parte.
As ex parte.
Yes, sir.
Sorry.
So in the moot proposition paragraph number 6, it is highlighted that Happy Babies started a new advertising campaign that get your Gamma sum and get Laddu and Peda free. So the council requests to focus on the word simultaneously. At the same time, the VIP Suites also advertised that they launched their advertisement campaign itself for Laddus and Peda only. They were the VIP Suites is a very broad, as they are contending that we are very broad, we are another subsidiary company, but they only advertised with Laddus and Pedas, and that too it was portrayed as baby boy and baby girl. So this shows that they synchronized and they coordinated their advertisements just to produce that they are involved in surrogate advertisement and to decide the consumer with the with this, because of this my client was also deceived by this practice. Secondly, sir, VIPL is working against the public policies as they are using ultrasound with the help in the congenital heart diseases. When someone is detecting a congenital heart disease, what is the purpose of using ultrasound in their test? They are using this ultrasound as the technology creates the picture of the baby, it can create the picture of the fetus. They can detect the sex very easily in this. Secondly, sir, the section 5 clause
In the
2.
name of Peda and Laddu.
Yes, sir.
So is there any violation of any law?
Yes, sir, there is a violation of section 5 clause 2 because it prohibits any
Of which law?
of PCP and AT Act, sir. My apologies to it. So in this case, it was highlighted that it is in memorial paragraph number 52 that it prohibits any person to communicate sex of the fetus by words, sign or any other manner. So the doctor here, after the results of gamma sound test, produced that VIP Suites boxes and there was Peda inside it. Secondly, it was after that few months the baby girl was born. So this shows that there was a chain of possession.
It may be a coincidence.
But sir, it's a chain of possession. There are two chains. Like firstly, the VIP Suites, the advertisements of VIPL came simultaneously. They brought a VIP Suites brought an advertisement only for Laddus and Pedas, and after that there were a large hoardings that were present in VIP Suites.
I'm not confused.
So the VIP Suites hoardings were present in the Happy Babies Hospital, which has the power to decide the consumer needs, and mostly a person who seen from.
How you are correlating VIP Suites and baby sciences as one figure, one identity, one entity? How? On what basis? Only
Sir,
because it is selling in Laddu and Peda and quoting it anthropomorphized in the name of baby and the son?
Also on all the web pages, receipts and everything of the Happy Babies Hospital, there was a site that surprised Laddu or Peda. So there is nothing surprise related to that. If you have anything, you can got Laddu or Peda. If it's just advertisement purpose for there, then what is the purpose of surprising in this? It clearly hints that they were involved in the detection of the sex of the fetus. Therefore, it is prohibited under the law to detect the sex of the fetus, and it should be considered as surrogate
So
advertisement.
what recourse was available to you under the PCP and AT Act?
So under the PCP and AT Act.
It is a punishable offence under the PCP.
Yes, sir. Under section 22 of the PCP and AT Act, any advertisement for the purpose of sex selection techniques is prohibited under the law. The council seeks permission to please extend the time with 5 minutes.
Okay. His question is, when the offence was, when it was an offendity, now how would you raise this problem before another forum like Consumer Commission?
So this
And
question-
whether Consumer Commission has got power to give any finding in relation to PCP and DT violation. Suppose we give any finding, you take this finding to the police forum, police, and you make an FIR, and then before the criminal court will look, yes sir, already finding given, now you start punish.
Sir, the original complaint we filed in the state consumer because there were many contentions for the misleading advertisements as well. There were surrogate advertisements, there were misleading advertisements. Moreover,
No, you didn't answer. You didn't
He has
answer.
not answered.
You didn't answer my question.
What is the jurisdiction of the consumer forum, even if there is a separate provision or special law? Can you invoke what sir is saying is that you can use the finding, if it is in your favor, go to the criminal court and say,
If I
see, I
give,
already have a
if I
finding.
give finding on violation of PCP and DT, okay, no doubt. So will this finding be not used by you or by any other person before law forum, criminal court? Look, yes, sir, finding already given and this hospital may be punished.
Indeed, sir. Sir, answering to your query that there was a lot of deficiency of services on the part of that. That's why we are here in the State Consumer Forum because they were deficient in services. All these contentions that are made, they show that they were deficient in their services. Secondly, sir, State Consumer Forum we approached because of this severity of these damages because we are facing. We wanted the compensation and we wanted the BIP
How
to
have you
stop this.
quantified your compensation only to 60 lakhs? And why not 6 crores or 6 lakhs?
So we are here
What
saying
is the
state.
basis of your computation of your compensation?
So, indeed, sir. So, answering to your query, firstly, that 2,40,000 were clearly there was.
That was the amount you paid.
Yes, sir. Secondly, sir, there was a loss of baby child, which though cannot be quantifiable, but it was we took it as a sum up of to contribute 60 lakh rupees. Moreover, sir. So the basis of this is also that there was a mental agony and.
How do you calculate? That's what my question. Simple question. Is there any basis reflected in your memo or not?
So, there were memo,
You should have
moot
claimed
preposition
60
is
crore.
silent on
You
this.
should have claimed 60 crore.
So, because the original complaint is filed against the,
You could have gone to National Commission.
so in the moot preposition, it is clearly
So
stated
you,
that the,
because it is state there for your. So if you had made it 6 crores, it would have gone to National Commission. Moot proposition would have come.
So
Also,
now
sir, there is a-
adding, supplementing his question, whether this commission can grant you, the state commission can grant you 5 crore, 10 crore, 50 crore or any amount you claim.
so the jurisdiction of the state commission is between 50 lakh to 2 crore rupees.
Where is it written?
It is written in the official gazette
47.
that was produced in 2021.
47 1A. So please read out what amount can be granted by the state commission.
Sir, in
Is there any limit, upper limit, lower limit? The latest amendment is 30th December 2021, making it from 50 onwards to 2 crores.
rupees, sir.
Now look at it. Whether there is any upper limit of granting compensation amount?
Sir, in the section 2 clause 47, section 2 clause,
Both are same. वो 10 crore कह रहा है, 47(2) is 10 crore.
yes,
I am
sir.
saying it may be granted 5 arabs. Isn't it?
So it is on the discretion of the consumer forum that what according
But
to them.
if the consumer commission does not have power, it has some limit, how can it go beyond that?
So according to the limit in the Consumer Protection Act, section 47 clause 2 subclause second. it
There is
was-
no upper limit. Even the district commission can grant crores Arab rupees, just like civil just senior division in the civil code.
My apologies, sir.
Okay, go ahead. On next point.
Sir,
Next point and conclude. 2 minutes.
It was said that it is involved in surrogate advertisements. I proved that it
It
is
says-
a prohibited goods. In the next issue number 4, it is submitted that BIPL was involved in surrogate advertisements as it is for using these diagnostic purpose, which is prohibited under the law. Secondly, sir, these advertisements, the elements that they were using, the VIP suites, the elements were used, they were gender stereotypical terms which is prohibited under the ASCI guidelines. ACA guideline number 5 clearly states that you cannot use any gender stereotypical term or any characteristics related to gender which harm the public health.
So it is some other different organization claiming some guidelines, framing guidelines. So we are bound.
And under section 18 of the Consumer Protection Act,
Okay,
CCPA has
clear.
in this case what happened was that there was a advertisement of soda and there was no market presence of soda. There was market presence of whiskey. And in that case, it was held that if there is no market presence of any product and only advertisements are there, then it will be constituted as surrogate advertisements, sir. So in our case, VIP Sweets, the client haven't seen any of the VIP Sweets shops and bakeries in any of the market, and this shows that there was no market presence as such, and therefore, sir, it is contended that as there was no market presence, the surrogate advertisement should be constituted, sir.
Your contention is that Laddu and Peda was the sole product produced in the same premises of the hospital. It is why it was not available in the market.
Yes, sir. It was for the first time the client have seen the laddus and pedas in the Happy Babies hospital itself and no other marketplaces, sir.
Okay, you can come to your last issue. So I think that remains to be.
Indeed, sir. So proceeding with my last issue, that greenwashing case, sir, BIPL is in, so the council seeks permission.
2 minutes.
Sir, in this case, please refer the page number 52 of the compendium. So it said that all environmental.
So your
The definition of greenwashing is given in this case.
So I don't understand what greenwashing has effect upon your case, because in the name of greenwashing, I don't think you can claim any compensation, or greenwashing had any health hazards as far as your child was found there was concerned.
So it is contended that the doses
Not
that the low
contended,
doses,
you have pleaded.
so the low doses, the doses that they are using in the gamma radiations are very hazardous even for the person who is in solid waste, even for the solid waste handlers. Even the Ministry of Health and Family Welfare produced a notice to that their radiations are really very violating. It is in Moot Proposition paragraph number 23. It is stated that they use these. The Ministry of Health and Family Welfare produced a report, a notice that these gamma radiations are harmful. Secondly, sir, they produce a large hoardings that they are very environmental conscious, and they use the word totally environmental friendly, which comes under the ambit of absolute claims. And according to this ACI guidelines, that Advertising Standard Council of India, it was said that no absolute claims should be mentioned in our case, and similarly this was mentioned in our case. My client got lured with that advertisement that they are very environmental conscious and nothing will be happened to my fetus. So we get there
And we are lured, enticed, and went for further operation.
yes, sir. Second, these advertisements which claims to be environmental friendly, it comes under the government sanctions.
Okay.
So just 1 minute more. I just wanted to complete this.
In 2 lines only.
Okay, sir. It is therefore submitted that the advertisements were using that they are very environmental conscious, were under the government sanctions, and according to the guidelines, it should not be used as an advertisement. Anything which comes under the government sanctions. So, if the sir is clear with the submission, the council seeks permission to proceed with the prayer.
Okay, just one question
Your
that
co-counsel is also there.
was asked earlier by Mr. Sinha. Now your greenwashing,
Yes, sir.
how are you, why are you relying upon the Environment Protection Act for that?
Sir, in the Moot Proposition, paragraph number 84.
That's in your memorial.
Yes, sir. Sorry, I apologize. It was in memorial, paragraph number 84, page number 25. Is the bench with us? So it said that environmental safety regulations comes under the section 3 clause 2 subclause B of the APA, which deals with the handling of hazard substances.
Okay.
That's why we use this term, sir. If the bench comes.
Next one.
raised, argument advanced and authorities cited, the council on behalf of complainant most humbly praised before this honorable Jharkhand State Consumer Dispute Redressal Commission that Baby Sciences India Private Limited is liable for deficiencies in services, VIPL to compensate Mr. Somarajendran ₹60 lakhs, VIPL to cease the use of dark pattern on their website, VIPL has been engaged in surrogate advertisements, VIPL is guilty of greenwashing, live to corporate will between VIPL and VIP Suites to hold both entities jointly and severally liable, award the complainant the litigation cost and attorney fees, and or pass any other order, direction or relief that it may deem fit and interest of justice, equity, fairness. Thank you.
Next, Steel Titan.
The council is appearing on the part of the opposite party, that is the hospital. So, the council would like to proceed to the arguments in the advance in the case. Currently, the first issue being whether the jurisdiction of this forum can be invoked. For this, we see the section 47 of the CPA 2019, which says that State Commission shall have the jurisdiction to entertain a complaint of the value of the goods and services where the consideration paid exceeds 1 crore and is less than 10 crores. Secondly, it is a complaint against the unfair contracts. Thirdly, appeal from the District Commission.
That is written. You try to convince
Yes,
her.
I am pleased. Sir, the consideration paid in the current case is 2,40,000, so it is not entertainable by this court. And previously, if we see that in CPA 1986, it was a case the compensation asked along with the consideration paid
It
was
was
seen.
11 Ambarish Shukla case was clear
Yes,
on
sir.
that point.
Correct.
You don't go back on that.
So, then the pecuniary jurisdiction of this court
So
cannot
you mean
be.
to say the case should have been filed before.
In the current
So if
forum.
a case is being examined by a higher forum, higher bench, will it be against the constitution or will it
Sir,
be illegal?
it will be if the higher bench, so procedure of law will be violated then because the CCPA itself is a three-tier mechanism.
Procedure of law,
States-
is it going to jeopardize your interest, prejudice your interest?
Definitely, sir, it is the dictum of the legislature that it has determined the pecuniary jurisdiction as to determine when you have to go to the which forum.
Okay.
Correct. It was clarified in the two bench
And in the light of 47 too,
unfair contract.
uh,
Sir, the council has not pleaded that it is under the unfair contract. Even if they have been pleaded,
they have
then
not pleaded that there was unfair contract.
no, sir, they are not pleaded. Even if it was unfair contract, we can see section 46 and any of the clause does not cover this definition and it cannot be a case of unfair contract also. Hence, it is not maintainable. Secondly, it can't be entertained as it was laid down by the two-judge bench of the apex court in Martin D'Souza case that whenever complaint is received against medical practitioners, it should be first referred to a group of medical doctors or doctors.
Martin
and then,
D'Souza case is by division bench.
yes, sir.
And before that, Jacob Matthew case by three-judge bench full court
Yes, sir.
has already been given.
Yes, sir.
Eh?
Yes.
So Martin D'Souza case, before admitting the case, call for the expert report is now no more a good case now.
Sir, then, as correctly pointed out by you,
And moreover, you have no, as per the moot court proposition, you have not raised any expert case issue.
correct, sir. Sir, it has been overruled, correctly pointed out, but still it is the discretion of the forum. And in this case,
So
the
discretion may
medical.
not be exercised.
But sir, it should be exercised because the medical intricacies which are involved, it is not beyond the comprehension of the normal man like us. It should be referred to the commission, the medical experts. Then only we can have an opinion upon that.
So your first point is this court has no jurisdiction. The second point is no expert report was called for before admitting the case as per Martin D'Souza case.
And even if we see the JJ Supra case which overruled it, discretion of the forum, it has to be exercised in current case. So secondly, even if we consider then the part of the deficiency, if we look into that, the council has pleaded that the deficiency was due to the claim of the accurately detecting the organization. I would like to take the bench over the facts of the case. It states that the Happy Babies Para 4 Happy Babies issued a press release in 2017 stating that they had developed a new technique to accurately diagnose and forecast the probability. It was the forecasting of probability, not accurately detecting the disease. Sorry, sir.
How can both go together, accurate and probability?
Sir, we are accurately detecting the probability.
Accurately detect
The probability. Yes, sir.
You're not probably detecting the accuracy.
Sorry, sir.
A probability can never be
You
an
are not
accurate.
probably detecting the accuracy.
We are not accurately detecting the disease, rather we are
That's what they are
detecting the
saying.
possibility.
How can they? Either you're accurate or it's probability. Both can't be.
Sir, we are saying we are detecting the probability only.
Both are contradicting each
No,
other.
sir, we can detect the probability also accurately. That
But
how
it
much
can-
chances are present, that is can also be accurately determined.
Okay.
And sir, the second argument that the enlargement of the heart which is being pleaded. So there is nowhere mentioned in the fact that it was firstly the cause of death of the baby. There could be other factors. As we can see, the mother was ill during the 1 month, which is a very critical period at that point of time. And she was supposed to take care of the baby. When she was admitted to the hospital, there is lack of care on the part of the mother. Secondly, it also can be a case that the enlarged heart.
Was there is any issue if the mother did not take proper care of the child?
How
There
does
is no issue.
after the birth of a child, how does the health of
After
the mother
pro-
contribute to the baby's health condition?
Sir, it
Postnatal
is
care.
the moral duty of the mother to take care of the
You have
baby.
given a package of postnatal care.
But sir, she was
You don't have a duty.
sir, correctly pointed out, but we have discharged the complainant. It is stated in the
That is
fact.
not.
And she got admitted to another hospital.
Mother did not.
See, how you discharge when finding that the child is suffering from a large heart?
But sir, the council which the opposite party is claiming that enlarged heart was not detected, that is the deficiency. They are not pleading that it
Obviously,
was.
they had come here, come there for this particular diagnosis. Your test results were not accurate.
Correct.
They were wrong.
Yes.
You promised to give them the.
Yes, sir.
In the garb of this, you conduct a test on sex determination. Your main aim was to give them, actually not detect any kind of disease, but to determine the sex. This is what is unfolding. Because after the test, even doctor says, Pida milai laddu. So the entire circumstances show that your only aim was to, determine the sex.
Sir, firstly, doctor never pointed out that
Yes,
this
it
is
is
what.
there. It's not
No,
there
sir.
in the-
No, there is no clarification from your side as to what you did about the neonatal care under para 4 of the proposition.
Sir, neonatal care, we
Because
had.
when you found that the child is with a large heart, the mother has also suffered some setback, you did not take
Not
any
the
care.
doctor.
We did not diagnose the enlarged heart, and it is not a deficiency also because there would be a condition
You
that
have-
after the test we had conducted, then the child had developed the enlarged heart.
Child?
Had developed the enlarged heart after we had conducted the test. So we cannot diagnose after the test. We are running the test for one time only.
Okay. So after the test is over, your responsibility is over
No,
according
sir.
to you.
Sir, not responsibility is over, but we have conducted that test. So we are been conducting other tests, but not that test. And all the other tests are within the ambit only.
Come to para 15 and para 18 of the moot proposition.
Yes, sir. Paragraph 3.
What does it say? So a hospital administration in a casual conversation said, do you like laddu or peda? Then,
Right.
and then para 18, the doctor says that if
Doctor
you are having
Hansen
second thoughts about anything, let us know. What does this mean?
So firstly,
So
as
therefore
was
the entire aim was to tell you that what is the child, and then if it is a girl child, if you want to have it, aborted or not. That's the entire thing. So everyone is involved in this entire process.
sir, it was
So
correct.
therefore you are doing something. So what surrogate advertisement, the first thing what it does is to advertise something which is prohibited in a deceitful manner.
Correct.
So exactly doing that.
So as I would like to point out, as you read the para hospital administration, it is the assumption of the complainant. It is never stated that a person was from the hospital administration.
No.
He was a person in the
So any
hospital.
person
He
from
was
the
some
general public can point out to
staff
something.
from your administration.
How would anyone know what is the
So
designation?
generally, if someone in the general public who is visiting a hospital is saying something, how can be that made
We
attributable
have,
to
we
us?
have not raised any such plea. We have not raised such plea.
No, sir, I am answering to whatever the
But
question.
you may. So can you
So,
tell me?
sorry.
Can you take any plea
Any pleading in the oral arguments, we are allowed to add anything.
Where is that?
where it is written? Rule book.
So they are in use.
You tell us.
Okay,
Sir, rule book is with them though. So
okay, you go
You
on.
must have read it.
Sir, I read it. I have the in the one.
Give them
on the
the
phone. On the phone.
Acha bhi dekhe.
Okay, sure. Secondly, the second thing which you have pointed out that if you are having any second
Just
thoughts
like, I
about
want
it-
to ask another question because the same question will come back. You said that the mother did not take care because she fell ill.
Yes.
That's not in the.
Sir, I am saying that could be an
Just
inference.
listen to it. And you can answer. So she had developed severe food poisoning, and it is attributable to the food supplied by your hospital canteen only. So in any event, it is your, unhygienic food which led to her food poisoning. So how can you escape the liability even otherwise?
So firstly, it was never the hospital's canteen. It was a shop which was operated by someone else in the hospital premises. So we cannot have the liability of them. We are given the space. They are operating something. Secondly,
Another question I would like to
yes, of course.
that let's for a moment assume that she was not able to take care of it because of her ill health.
Yes.
Will that amount to contributory negligence? If someone is genuinely incapable of doing a thing, can that amount to contributory negligence on their part?
Sir, it is, according to me, it will be a case of negligence, but she is not under any legal duty. Rather, it is a moral duty of the mother to take care of the child. So,
But
legally, it won't be a case.
you are saying that it is because of her ill health that she is not able to do so.
Yes, sir.
And that's anyway we are not a moral forum that we can say that there is a moral.
There is no case that says the child died only because the mother did not take
So,
care.
but that is also not the case. The child died due to the enlarged heart. It is also not written. So, it is an inference which we are suggesting.
So have you brought any evidence, or is there your contention that a child with enlarged head will have no problem at all?
So, currently, we do not have any medical jurisprudence on the matter.
Okay, proceed.
Thirdly, I would like patterns. As the guidelines which regulates the dark patterns are guidelines on the regulation of dark patterns. The guidelines came into force on 13th November 2023. The cause of action of the complainant arose in August 2023. When there can be no guideline, how can such claim arise? There is no regulation to be complied with.
With no retrospective
Application. For that, we have the case of the Supreme Court in Ella Brothers Indoflora versus Committee of Central Excise. It says that there cannot be any retrospective application of any rules or regulations until it is expressed by the legislature or opined by the apex court. So currently this is not the case. So when there was no regulation,
What were the facts in those facts?
so I am aware about the ratio of the case.
What is the ratio? And how is it applicable to your case? It is a merely clarification.
So basically, the ratio.
Have we understood what is the? It is nothing new which is being brought into existence. It is only defined. It is something which already exists. It's a clarification notification. Okay. And anything which is clarificatory always has retroactive operation. So therefore, it is not an application rule or a guideline which will necessarily have to have a retrospective application. It is not a penalty which is prohibited.
So, but it will be against the principles of natural justice. Firstly,
Natural justice which principle?
secondly,
Which principle of
sir,
natural justice?
it is a rules and regulation
No,
which
which
is
principle
creating
of
some.
natural justice? I am asking a question. Which principle of natural justice is being violated?
So the law is not clear to public because they are creating a regulation which is creating something which is saying something is illegal from right now. How can they have the retrospective application of that thing?
It is nothing. It is there is a bar on punishments, criminal law.
So dark patterns were not regulated prior to the guidelines.
Forget it. Misleading. Forget dark pattern. Forget it. Whether someone can allege that this advertisement is false and misleading. That false and misleading advertisement was there all along.
No, sir, it was not there.
It was there. All industry practices have prohibited it right from 2000.
Okay, sir. Generally, I agree.
Generally, it is there.
So
Even in the guidelines, was
Misleading
not there.
advertisement guidelines are of 2022.
Yeah, sir.
They have been there.
Sir, I am saying the ingredients of the dark patterns are not made
So
up in the case.
ultimately, dark pattern it's
It is one of the components.
components of misleading.
Sir, misleading advertisement is a very broad thing. The legislature had come up with the guidelines because it is a very narrow thing which they are trying to regulate right now.
That is already there in the statute. Already misleading information, misleading advertisement.
So, but explicitly it is not mentioned. If it would have been there, why the legislature would have brought to another
It's
statute
not
to
a
regulate
legislature
that?
which, no, it's not a statute, it's a rule. It's a
So,
guideline.
CCP, it's a rule, correct? It is a rule. But it has a statutory backing. It is a delegated legislation. And the CCP is empowered to.
CCP has not made a rule, it's a guideline issued in terms of a
By the
That
statute.
is why it is not made punishable also. Nowhere it is made punishable.
But sir, it makes something illegal. So it is a law.
It does not make anything illegal, it was always illegal.
Sir, explicitly it was never
It
mentioned
doesn't
in any
require
of
to
the
be
rights.
explicitly said. That's what I'm saying.
Okay, be very submissive. Okay.
So the other three issues would be like my counsel would come. Thank you.
The council seeks the permission to hold it. Much obliged. 3, 4, 5. To start with the issue, the first issue is, can BB Sciences India Private Limited and BIP Suites Private Limited be considered as one entity or connected entity for the purpose of determining surrogate advertisement? Sir, in the present case, the BIP Suites Private Limited, though is a subsidiary company, but the same operates in a totally different domain. BIP Suites operates in the production of sweets, sale of sweets and confectionaries, whereas BIPL runs a
Where
new
do you
unit.
have your shops?
Yes, sir.
Where all do you have your shops to sell sweets?
Sir, it is mentioned in the factual matrix that only the complainant had not seen such shops anywhere. But it is nowhere mentioned that they are not present anywhere in the
No,
country.
your shop is in the premises of the hospital or not? He's asking this question.
Sir, the sweets are given by the hospital to the complainant. There is no mention of shop being present in the hospital in the actual matrix.
Okay. In the latter part of the proposition, it is mentioned that you are operating from the same location, from the same IP address.
Certainly, sir.
So it means that you are having operating from the same location.
Sir, the IP addresses that has been put up on the website was from the third party. We cannot say that the IP address which was put was from the side of the VIPL hospital. And we are arguing from...
You mean to say physically they were operating from some other places, but IP address, website, etc. may be the same.
Sir, the IP addresses was also not same because it was put up
It is
by the
same.
third party.
It is same.
Sir,
I
IP
mean, it is
addresses...
same.
It is written in the factual matrix that this is same, but then it is
You
also...
say what is
Even if a
what is
third
written
party
in the
puts it
factual
up.
matter is an admitted fact.
Yes, sir.
Section 58 Evidence Act says admitted fact need not be proved. It is already proved fact.
Yes,
So
sir.
this is already proven fact. You are operating from this and
What
this
sir is saying
location.
in the moot
Even
proposition. Yes, yes.
Even if a third party puts it up, can they put it up from your registered address?
That's the point.
Sir, certainly the question is appreciated, but
No,
they
it's not a
can-
question, it's a fact, say.
Fact is there.
Sir, if I agree on this point, they both are subsidiary companies, and subsidiary company can have same IP
I
address
have one
also.
question for you.
Yes, sir.
This is the allegations of the complaint. The only problem with that report is that it is inconclusive so far as who is responsible. So either you are responsible or the switch company is responsible. Someone is responsible. That is what we can, maximum the court can do. You have not said anything in your memory that the findings of, you have not even said that the findings of this inquiry is wrong.
Sir,
You have not said so.
sir,
So
according,
therefore we will take it that you have accepted that. So the allegations stand proved by an independent investigation.
sir, according to the rule book, we can make extra
No,
oral
you
submissions.
can't, you can't. I have read
Yeah,
it.
no,
Teams
yeah.
participating in oral rounds while making their submissions are not confined by the content of their memory, but that does not mean that you will make out a new case. Any question I put, yes sir, this is the answer. Then there is no end to it. We can't expand the interpretation of this rule to mean that anything we ask, you will say yes, no, I am disputing the... If I had not asked the question, you would have said, not said it.
Certainly, sir,
This
but
rule
oral
can't-
submissions to your answers can be answered immediately.
Sir, if I can answer the question.
Come.
Sir, as you pointed out, there are two cases. Either the hospital is responsible or the VIP suite is responsible. Third case, no one is responsible. That was the case.
No. He said that someone is responsible.
Sir, attributable part is still disputed. So we both are claiming that we are not responsible for the
You
case.
have not said so, that's what I am saying. You have not
And sir, IP address thing was for the reviews. The reviews which were
No, you're not
present on the
getting my point.
website.
You're not getting my point. The entire allegations made by the complainant have been found to be true by the investigating wing of CCP. You in your memorial have nowhere stated that the findings arrived by the investigative wing are not correct. I'm not saying how it is not correct.
Yes.
Someone should at least make an allegation. Right? You could have improved your case.
Yes.
Now, having not said so, everyone is bound by that investigative wing. Or the parties, not us. The point is, Therefore, how do you get out of it? Now it's only a question of fixing responsibility.
So
Else, anything else that there has been no, greenwashing or any kind of, bad, that stands conclusively proved.
but sir, if this was the case, then we would have to look into the case, the report which was
You
submitted.
are not
by
asked for
CP.
any of that. That is the case which you should have set up.
But sir, that is currently not the case. The issues are somewhat different. So
Why?
we don't have the report, so we can't even assume that
You
we
have
are
said so.
having.
Sir, answering to your further questions, these both are subsidiary company and they are together only for their marketing gimmick. In the case of Vodafone International Holdings, as sir has correctly pointed out, it's a taxation case, but the purpose of putting up a subsidiary company is held here. Supreme Court held that subsidiary company are the integral part of corporate structure. Activities of the company over the years have grown enormously and the structures have become so much complex that companies would have to depend on their subsidiary company for better return and for the growth of the company. For the same purpose, sir, the both companies have come together. That is their marketing gimmick and to gain
The
the...
Supreme Court itself is saying that it is integral part of the original company. We are quoting the same thing.
Yes, sir, I am quoting the same thing, but they are part of the subsidiary
So
company.
do you contend that the company law, the tax law, the financial instructions will be applicable on consumer field?
Sir, the issue is raised about connected entities and it can be decided by the company law. Sir, moving further,
Have you heard about the lifting of the corporate veil?
yes sir, I am coming further to that issue only.
And what is the difference between lifting and piercing the corporate?
Sir, counsel is currently unaware of that.
Sir, if I may answer that.
No, let her answer. Then
Sir, the Supreme Court further in the case determined the conclusive effect of relationship between holding company and subsidiary company and said that legal relationship between holding company and subsidiary company is that they are distinct legal persons and the holding company does not hold the assets of the subsidiary company. And at most the holding company and subsidiary company can be considered as single economic entity but not as connected entities. The judgment also cited US versus Best Food, which says that it is a general principle of corporate law and legal system that a parent corporation is not liable for the acts of subsidiary. Mere ownership, parental control, management, etc. of a subsidiary company is not sufficient to make the whole parent company liable. As sir has pointed out, that corporate veil can be pierced. It is mentioned in the case, but only if the parent company is held liable for anything wrong. Here, until now, the company has not been held liable for anything wrongly done. Hence, in the present case, these both are separate entities, and so they don't fall under the connected entity. The council would like to proceed with the next issue. The next issue is whether the BIPL has indulged in surrogate advertisement of its diagnostic methods. It is humbly submitted before the forum that the BIPL has not indulged in any kind of surrogate advertisement of its diagnostic methods. BIPL Hospital has set up a subsidiary company in the name of BIP Suites and they have advertised it in the following words: get your gamma sound test done and get a laddu or peda free. But it was just a marketing gimmick, sir. To make the advertisement look more appealing, they have formalized it in the same way as a laddu or peda. And sir, section 2H of the guideline, CCPA guideline says that advertisements for goods, product or service whose advertising is otherwise prohibited or restricted by law by circumventing such prohibition or restriction and portraying it to be an advertisement for other goods, product or service, the advertisement of which is not prohibited or restricted by law.
That may not have been prohibited, but by in the name of laddu and poda, you are
That is the only marketing.
You are
Most of
marketing, you
the
are
companies
commercializing the effect of laddu and peda in the name of the boy and his person.
By BIPL.
What marketing?
Huh?
BIPL. We are arguing from the side of BIPL hospital.
How is the marketing?
Sir,
It is connected directly to the.
sure.
No, whose advertisement was it? Laddu Peda.
Sir, laddu.
It
The
was not
statement.
BIPL's.
Sir, the statement that was made, get your gamma sound test done and get a laddu or peda free, it was made by BIPL. The BIP Suites anthropomorphized it as a laddu and peda.
So
So,
how the answer?
yes sir, certainly. But they were subsidiary companies and they were connected for the purpose of economic growth only.
My
Yes, sir.
last point. You are raising this point for the first time. You are raising this for the first time because you have been held expert.
Yes sir.
Huh? So how you can raise all these points? You have not raised any point on the cause of non-appearance.
So the
Why you did not appear after getting the summons, notice, etc.?
So the counsel for the opposite party, as it is mentioned in the factual matters that they are ex parte. So we are just arguing from the VIPL side. Yes, sir. Sir, secondly, here in this case, the complainant was given a box of
You
data
have two
as.
more issues to cover?
Yes, sir.
Okay, you take 2 minutes on this and then.
Okay, sir. Here in this case, in the para 18th of the moot proposition, it was given a box of peda was given to the complainant, which he himself mentally associated it with a baby girl. Sir, it was his presumption that he associated it with the baby girl. The hospital was not. The hospital was silent on this part. The doctor never said anything about this. No one from the hospital.
Hints were being dropped.
Sorry, sir.
Hints were being dropped.
Sir, hints were just a mere coincidence. They cannot be connected, and then we can be held. This was a mere coincidence, sir. Yes, sir. The next issue that concerns us is about greenwashing. Sir, this also does not have any retrospective application, but if it has any. Sir, the greenwashing.
Are you agreeing with me or disagreeing?
Sir, I am explaining it further.
Retrospectivity.
Sir, I am explaining it further. Yes, sir. If it falls under the purview of greenwashing, apart from the retrospective application, sir, then also the greenwashing guidelines defines it as any deceptive or misleading practice which includes concealing, omitting or hiding any relevant information by exaggerating, making vague, false or unsubstantiated environmental claim, but shall not include use of obvious hyperboles and puffery. Sir,
Do you have an environmental clearance?
sir, puffery is excluded in it, and we are just doing puffery here. And puffery is totally excluded from the purview of greenwashing. It is mentioned in the statute.
Do you require some clearance under the Environment Protection Act for
Yes.
installing a gamma ray?
Sir, it is not mentioned in the greenwashing guidelines.
No. You are also referred to the Environment Protection Act. It is there. Have you checked the Environment Protection Act?
Sir, council seeks
You simply say there is no mention.
Everything can't be mentioned. No? Something has some research has to come from there.
Okay.
So the greenwashing was a mere issue that was raised up for disguising the opposite party, and it was just a mere puffery that was done by claiming that environmental friendly thing was mentioned there. And also, sir, the notice that was issued by Health and Family Welfare was just a mere warning and about the disposal of the machine. The company has never claimed about an environmental friendly disposal of the machine. It has only mentioned that it was environmental friendly because it uses less electricity first, then all other alternate tests. It was just a mere comparison only. It was not stated that during the disposal this machine would be harmful. So this machine is harmful during the test, environmental friendly during the test only, and as it uses less electricity. This, yes sir, it is mentioned in the factual matrix also. So the last issue is about contributory negligence. The counsel for the opposite party thinks that the complainant was negligent at various stages of the incident. He himself owed a
If
duty.
you burn tons of coal in a dark room without any electricity, it is environmental friendly.
No sir, but
Without electricity.
certainly sir, but we have mentioned
What
that.
is it?
Sir, we have certainly sir. We have mentioned that
What logic?
according to the guidelines, sir, if we are mentioning any such attributes, we have to mention how is it being environmental
Gamma
friendly.
rays are very environmental friendly.
Sir, it is certainly it is not, but all the tests that are being conducted in various hospitals in the country, they use gamma radiations such as ultrasound tests, scanners, and other detective techniques.
We are done.
Sir, the council seeks extension for 1 minute for.
No. Let him speak. Conclude.
You want to conclude? You want to conclude?
Yes, sir, I have. This last issue is about contributory negligence, and the complainant was negligent at various parts, as he has hurriedly, very quickly filled the details which was given on the website, which should not have been done by him, and it is.
Only said 3 receipts left. Therefore, that's the case.
Sir, but it was left for August 2023. They could have examined about their baby in September.
No, can you, when it comes to a pregnancy that's already ongoing, can you postpone the tests?
Sir, so he can approach to a different hospital.
No.
Did you ever suggest for that?
Sir, we are advertising our scheme, so why would we
That's
refer
what
to?
is prohibited. Now you can't create a sense of urgency. You go to any online shopping, you will find that one piece left. Everywhere I should be there. There are hundreds of pieces. Airline ticket, 4 seats left.
Certainly, sir, but that's when a
That's
customer
not
has to
the-
behave as a prudent man.
Thank you.
Okay, over. You
Sir,
come through.
So council seeks permission to approach for these rebuttals.
it was an honor having you before
Thank
this
you.
bench. Much obliged.
We are under section 47 clause 2 of the Consumer Protection Act.
Yes.
It allows the unfair contracts up to rupees 10 crore rupees, sir. And in our case, it was around
No,
60
then
lakh.
you are putting concession. Again, it is using the word consideration.
Yes, sir.
47?
47 subclause 2, sir.
Has been used.
So in this case,
So, is how the state commission has jurisdiction to decide a matter.
What is the unfair contract?
so unfair contract
Have you
here
not
is,
come against the loss of your child? Or have you come against the wrong treatment? What is the case there?
so here unfair contract means because I that they will produce their services and they should be the services should be provided there.
So then in every case it's a deficiency of service will be an unfair contract. It has been defined, unfair contract has been defined.
Yes, sir. It is defined under section 2, clause 28 of the.
How it is.
So in this unfair contract here, because
And have you said so in your petition?
so I use the word misleading advertisement that they are
That's what I'm
using.
saying. Therefore, these are jurisdictional facts. In your memorial, you have not said so. That is an unfair contract and therefore we are invoking 47 Roman 2, 1 Roman 2. Not said so.
My apologies to that, sir. Please submit our oral submissions to this. And as the unfair contract was there, the party was not to comply with the contract because they used the unfair methods like gamma sound test to detect the sex of the fetus. Secondly, sir, they contended that though no expert opinion was there, therefore there should not be it should not be in the compliance to this. So in the compendium, page number 11, it said that in Anil Dutt versus Vinesh Hospital, it was said that there should be an expert opinion is not required in our case. Expert opinion is not compulsory in our case to be produced by the medical services.
In
It
which
was
case?
in Anil Dutt versus Vinesh Hospital, sir.
Page number.
Page number 11, sir. Paragraph number 16. So in the first line, it is referred that it is not mandatory that before admission of medical negligence complaint, the council requests the bench to please
That
extend
has already been done away with.
We are running short of time.
Martin D'Souza is not the authority now for the proceeding was not perhaps brought to the notice of the bench. That is why it was left. The issue could not be decided. So something other ratio was given. So that point is okay. So don't focus on it.
So
Jurisdiction point you have clarified. Jurisdiction point you have clarified.
Yes, sir. So
Anything
there are
more?
many other rebuttals as well that they question the mother's moral duty as well. So this we accept that there is a moral duty of the mother, but it was not performed because of their deceptive practices or because of their treatment. She couldn't. She got
Maybe
the
mother
food
was
poisoning.
not in a position to take care of the
Yes,
child
sir. She
because
was
he
not in a
suffering.
position because of their treatment itself. There was a tea stall shop that was working in the parking lot, and as there was no provided a proper canteen facility, the mother of the Uma was compelled to use these tea stall foods, and because of that, she discovered she was diagnosed with the food poisoning, and because of that, there were many medical complications that arise to it.
Oh.
Thank you, sir.
So if I may answer those questions.
Counter rebuttal is not permitted. Why?
This section 15 of CPC says that all suits must be filed in the lowest court of jurisdiction which is permissible. Is there any such requirement under the consumer protection?
Sir, for that the reliance is played on State versus Jacob Matthews, where the court opined that no procedure codes or evidence act or any other codes are applicable to this.
So
Please
question
understand the
is,
question.
now since you say jurisdiction is not there in terms of section 47,
Yes.
pecuniary jurisdiction of state commission is not there.
Yes.
Now, even assuming that the contract is of lower value than is permitted, in CPC there is a specific bar on instituting it in a higher court when the pecuniary jurisdiction is not.
Okay.
Is there a similar bar under consumer protection?
So currently I am not aware of that. So but that for that unfair contract it is defined and it says that various requirements, the 6 sub-clauses, it does not fall under any of the
Okay,
sub-clauses.
no, so on those
So just
we have not
stating that
questioned.
it is unfair contract, we cannot assume that it is unfair contract. And generally on the food point, as the opposite side complainant say that we did not provide food, we are under no statutory duty to provide food to the complainant. The hospital in no statute or legislation by anyone, by any government or anything has a duty to provide food.
This is a very big university. It does not have any nearby shops, restaurant, hotels. So the university has got no responsibility to provide a food facility to the incomers, the parents in the
Sir, it will be a good time.
See, is there a requirement to provide, let's say, toilet facilities?
Yes, sir.
Where is that?
Sir, technically providing the toilet facilities, the potable water, it is also included in Article
No,
21 of the
toilet is not potable water, sorry.
I am just including any other things, including that.
No, so fair enough. So just because there is no requirement for toilet facility, if a hospital of that size says that we are not going to provide toilet facilities in the entire
Sir, it is a requirement according to the local building codes. It is a requirement. The building code cannot be passed if you don't have the minimum requirements of the toilets and everything available. And as far as the university is concerned, it is the UGC which governs. The hospitals are governed by the various legislation of the state governments. Currently, the state government does not have any legislation to say that he has to.
Okay, time over. Thank you. Thank you, East team. I'm studying. Shall we conclude?
Okay.
Okay, thank you.
So all the best.
All those and message to all of you. All the best, beta.
Thank you so much.
Okay. Blessings.
ठीक है जी, उस तरफ जाइए सर, उसको उस तरफ है ना सर, खड़े हम लोग उसी तरफ उतरेंगे आप जान। अच्छा मना कर दिया सर।
request everyone to please rise for national anthem. I request everyone to please settle down. Dignitaries, esteemed guests, faculty members, dear participants, students, and everyone present here. It is with immense pride and deep sense of gratitude that I stand before you today as we gather to celebrate the valedictory ceremony of the National Moot Court Competition on Consumer Protection Laws 2024. The prestigious event has been organized by the Chair for Consumer Research and Policy at the National University of Study and Research in Law, Ranchi, in joint collaboration with the Ministry of Consumer Affairs, Food and Public Distribution, Government of India, New Delhi. Over the past 3 years, this competition has served as a vibrant platform for the aspiring legal minds from across the country to show their advocacy skills, intellect, and the passion for law. The journey from conceptualizing this event to witnessing its successful conclusion has been one of collaboration, perseverance, and shared purpose. Today, we are privileged to have amidst us an esteemed gathering of dignitaries who have not only graced this occasion with their presence, but have also elevated it with their wisdom, insight, and unwavering support. Every event is enriched by the contributions of its guests, and today is no different. We have prepared a token of appreciation for our esteemed dignitaries as a small gesture for our immense gratitude for their presence and support. May I now request our Honorable Vice Chancellor, Sir, to felicitate our Honorable Governor of Jharkhand, Shri Santosh Gangwar, Sir. May I now request our Assistant Registrar, Dr. Jisuketan Patnaik, Sir, to please felicitate Shri Anupam Mishra, Joint Secretary, Department of Consumer Affairs, Food and Public Distribution, Government of India, New Delhi. Dr. M.R.S. Murthy to please felicitate our Honorable Vice Chancellor, Sir. To felicitate Shri Vikram Hegde, Advocate on Record, Supreme Court of India. Dr. Kaushik Banerjee to felicitate Dr. Jagadish Halishetty, sir. It is now my privilege to invite our Honorable Vice Chancellor, Professor Dr. Ashok R. Patil, to deliver the welcome address. Law and his vision for academic excellence have been instrumental in establishing the chair of consumer research and policy at NUSRL Ranchi.
Respected Shri Santosh Gangwar, Governor, State of Jharkhand, Shri Anupam Mishra, Joint Secretary, Department of Consumer Affairs, Government of India, Shri Goswami, President, Jharkhand State Consumer Commission, all the dignitaries, participants, faculty members, and dear students. I welcome everyone present here in the valedictory session of a 3-day moot court competition on consumer laws organized by Chair on Consumer Law of this university and along with Ministry of Consumer Affairs, Government of India. At the outset, I express my gratitude to Honorable Shri Santosh Gangwar, Governor, State of Jharkhand, come Rector of our university. Your invaluable presence amidst us today is both a matter of pride and encouragement, sir. I welcome Honorable Justice Sujit Narayan Prasad. He is on the way, so in his absence, I welcome him also. I extend warm welcome to Shri Anupam Mishra, Joint Secretary, Department of Consumer Affairs, Government of India. Your presence here reflects your deep commitment towards the rights of consumers and consumer law. I would like to begin by saying that it has been a great event that has brought together the brightest legal minds from across the country. It has promoted rich intellectual engagement and has encouraged the spirit of excellence in the legal advocacy. It must have been a great learning experience for all the participants. I wish to first express my the heartfelt gratitude to them. Their hard work, dedication and passion for consumer law have made this moot court a great success. I wish to say this all the participants. You have not only demonstrated your legal acumen but also your commitment to the larger cause of consumer rights. I hope in the years to come, all of you will contribute towards strengthening the consumer law jurisprudence in India. The moot court competition would not have been possible without the support and guidance of our esteemed panel of judges. I wish to express my heartfelt gratitude to Honorable Mr. Basant Kumar Goswami, Mr. Indrajit Sinha, Mr. Vikram Hegde, Mr. Hal Shetty, and all the judges who have guided the participants with their valuable insights and expertise. Your dedication and contribution to the event have helped elevate the quality of this competition and have ensured that all the participants gain wealth of knowledge and experience that will serve them throughout their legal career. The theme of the competition, consumer laws, is both timely and essential in a world that is becoming increasingly complex and interconnected. Consumer rights have never been more critical. I also wish to acknowledge the effort and enthusiasm of our students and faculty members who have worked tirelessly to organize this event. Their dedication has ensured that everything has run smoothly. To all the teams that participated, I commend you for your remarkable research, preparation and legal arguments that you presented over the past 3 days. As we come to the end of this competition, I hope that each one of you leaves here with not just trophies and accolades, but also a deeper appreciation for the importance of consumer law in our society. Finally, I would like to thank all the distinguished guests, dignitaries, and every individual who has contributed to the success of this event. Your presence here today is a testament to your commitment to the advancement of legal education and promotion of consumer law. Once again, I welcome you all for this valedictory session. Thank you.
Ms. Anushka Saxena, Teaching Assistant and Coordinator for this event, to present the highlights of this moot court competition.
Thank you, Shruti. A warm good afternoon to all the esteemed dignitaries and guests and dear participants and dear students. It is with great honor and immense pleasure that I extend a warm welcome to each one of you to the valedictory ceremony of the Consumer Law Moot Court Competition 2024. Today we gather here to celebrate the confluence of intellect, advocacy and legal expertise as some of the brightest minds from across the nation come together to argue on the intricacies of consumer law. Moot courts as a vital academic exercise have refined the landscape of legal education. Recognizing this, the government and academic institutions have taken strides to integrate mooting as a cornerstone of legal education. This year, moot proposition was fully drafted by Shri Vikram Hegde, Advocate on Record, Supreme Court of India, which revolves around the modern issues such as greenwashing, misleading advertisement, dark patterns, ethical corporate practices, and dark patterns. The proposition challenges participants not only to display their legal acumen, but also to explore the delicate interplay between law, ethics, and public welfare. Our journey to this stage has been marked by an exciting series of rounds. From the initial participation of various streams across India, 8 teams advanced to the quarterfinals. Following intense deliberations, 4 teams progressed to the semi-finals, culminating in the final rounds where the best 2 teams, Spenix and Titan, Institute of Law, Nirma University, and Law Center 2, Faculty of Law, Delhi University, vied for the glory. Throughout this journey, we are reminded that winning or losing is secondary to the invaluable learning and growth that such experiences foster. As we embark on this intellectually stimulating journey, I encourage all the participants to exhibit professionalism, perseverance, and passion for the law. Let us now witness the brilliance of legal minds in action. May the arguments commence and may the best team emerge victorious. Thank you and best wishes for a memorable and rewarding competition. Thank you.
Thank you, ma'am. Next, I invite Ms. Soni Bhola, Assistant Professor of Law at NUSRL Ranchi, to introduce our Honorable Chief Guest, Shri Honorable Governor of Jharkhand. Guest of Honor, Honorable
Good afternoon, everyone. It is a distinctive pleasure for me to introduce Honorable Santosh Gangwar sir, the Governor of Jharkhand, and also our Chief Guest today. A veteran leader and a dedicated public servant, Honorable Gangwar sir's illustrious career in politics spans decades, marked by significant contributions to governance and policy making. Honorable Gangwar sir has represented the Bareilly constituency in the parliament since 1989 across multiple Lok Sabha terms, and over the years he has held several prominent positions, including the Minister of State with independent charge for labour and employment, where sir played key roles in advancing policies for the labour force of the work of the nation. His expertise is also reflected in his leadership roles as the Chief Whip of the BJP during the 14th Lok Sabha and as the Chairman of Public Accounts Committee as well as the Committee on Public Undertakings. Born in 1948, Honorable Gangwar sir completed his BSc as well as LLB from Agra University. His early commitments to public welfare was evident in Bareilly, where he championed transformative projects. He has also been actively involved in financial inclusion as the chairman of Urban Cooperative Bank in Bareilly since its very inception. In Indian politics, Honorable Gangwar sir has served in critical ministries including Textile, Finance, Petroleum, Natural Gas and the Parliamentary Affairs Committee, demonstrating his versatility and dedication to public services. His contribution has had a lasting impact on the labour sector, the textile industry as well as the financial landscape of the entire country. He was appointed as the Governor of Jharkhand in June 2024. And since then, he's continued his journey of serving the nation with the same zeal and commitment that has defined his long and illustrious career over these decades. His Excellency's vast experience and deep understanding of public policy makes him an inspirational figure for both the students and everyone who's present in the room today. Sir, we are truly honored to have you here with us, and we look forward to hearing your address. Okay, so I'll proceed with introducing all the other guests.
No.
Okay, sir. So, sir.
यहाँ पर उपस्थित माननीय न्यायाधीश बसंत कुमार गोस्वामी जी, आप कार्यकारी अध्यक्ष राज्य उपभोक्ता नियंत्रण आयोग झारखंड, श्री अनुपम मिश्रा जी, संयुक्त सचिव उपभोक्ता मामले भारत सरकार, डॉक्टर अशोक आर पाटिल जी, कुलपति NUSRL रांची, यहाँ उपस्थित सभी विधि के जानकार साथीगण, विश्वविद्यालय के पदाधिकारीगण, प्रेस व मीडिया के साथियों और उपस्थित भाइयों बहनों, NUSRL रांची द्वारा आयोजित इस राष्ट्रीय मूट कोर्ट प्रतियोगिता के समापन समारोह के अवसर पर आप सभी के बीच उपस्थित होकर मुझको प्रसन्नता हो रही है। इस प्रतियोगिता का विषय उपभोक्ता कानून, उपभोक्ता संरक्षण कानून न केवल विधिक प्रणाली के संदर्भ में प्रासंगिक है, बल्कि हमारे समाज के हर नागरिक से प्रत्यक्ष रूप से जुड़ा हुआ है। वो हर व्यक्ति, चाहे वो किसी वर्ग या आयु का हो, अपने अधिकारों के प्रति सजग रहना उसका कर्तव्य है और जिम्मेदारी भी है। मैं समझता हूँ कि यहाँ पर जो बातचीत हो रही है, मुझे लगता है कि कुछ लिखा हुआ पढ़ने की ज़्यादा आवश्यकता नहीं है। कुछ बहुत अधिक बोलने हम खड़े नहीं हुए हैं, पर मैं इतना अवश्य कहूँगा कि हमारे देश में कानून की जो प्रक्रिया है, ये बात सही है कि कभी कभी माननीय सर्वोच्च न्यायालय और उच्च न्यायालय दोनों ऐसे फैसले देते हैं जो व्यक्ति के जीवन में असर डालते हैं, प्रभाव करते हैं और उसका एक लाभ भी सबको मिलता है। पर निचले कोर्टों में कभी कभी ऐसी बात आ जाती है, सोचना पड़ता है कि निचले कोर्ट्स में कैसे सुधार हो। और मैं ऐसा मानता हूँ कि क्योंकि मैंने उस साल लॉ किया जिस साल लॉ 3 साल का हो गया था, और उसके बाद से हम उत्तर प्रदेश के थे, तो इसलिए हम बहुत सी व्याख्या में जाना नहीं चाहेंगे। पर ये अलग बात है कि हमने वकालत नहीं की, इत्तेफाक से आपातकाल लग गया और हम तत्काल लॉ करते करते जेल चले गए। और 1 साल रहने के बाद जब हम लौट कर आए, तब हमारा सोच राजनीतिक सोच हो गया और हम इस कानूनी प्रक्रिया से अलग हो गए, और हम तब से ही लगातार सक्रिय हैं। और ये अब जिस स्थान पर हमें ये विश्वास नहीं था कि हम यहाँ पर आ रहे हैं। हमें लग रहा था कि हम लोकसभा लड़ेंगे और हमारा क्षेत्र, जो लोग लोकसभा की प्रक्रिया को जानते हैं, तो हमारा क्षेत्र ऐसा क्षेत्र है कि यहाँ पर जीतना एकदम आसान नहीं है, पर हम लगातार लोगों के प्यार और स्नेह से 8 बार लोकसभा जीते और 9वीं बार भी उम्मीद है कि हम जीतते, पर ये कहा गया कि आपको चुनाव नहीं लड़ना है, आपको कुछ और जिम्मेदारी दी जाएगी। पर ये जिस क्षेत्र में हम हैं, ये क्षेत्र भी बदलाव का क्षेत्र है, क्योंकि देश की राजनीति में जिस प्रकार की प्रक्रिया है और अब जिस स्थान पर हम हैं, यहाँ पर तौर तरीका में सब बदलाव है। और लोकतंत्रीय व्यवस्था में जनप्रतिनिधि बने रहना और बने रहकर अपने को बनाए रखना और बार बार जीतना ये आसान नहीं है। अभी अभी आपके यहाँ विधानसभा के चुनाव हुए हैं और परिणाम आप लोगों ने आज देखे होंगे। हम जल्दी इसलिए आ गए कि जो सरकार अब चल रही है वो अभी हमसे मिलने आ रहे हैं वे लोग, तो इसलिए हमको जल्दी भी जाना चाहते हैं। पर लोकतंत्रीय व्यवस्था दुनिया में जिस प्रकार की है, हमारे देश में जिस प्रकार से हम लोग चला रहे हैं, क्योंकि हमारे अड़ोस पड़ोस के जितने भी देश हैं, अगर आप ध्यान करें तो किसी में एक सही ढंग से लोकतंत्रीय व्यवस्था के हिसाब से काम नहीं हो रहा है। तो उसकी व्याख्या करने का संदर्भ विषय नहीं है, पर कानूनी प्रक्रिया को हम बनाकर रखें। और कभी कभी हम देखते हैं कि माननीय सर्वोच्च न्यायालय ऐसे फैसले देता है जो सरकार के लिए समस्या और तकलीफ भी पैदा कर देते हैं। ये हमारे यहाँ की विशेषता है और हम इस कोशिश में हैं कि इस प्रक्रिया में हम जिस प्रकार से इस समय देश में चल रहे हैं, क्योंकि मैं उत्तर प्रदेश में जिस जनपद का रहने वाला हूँ वहाँ पर सारे कोर्ट्स हैं और सभी प्रमुख न्यायाधीश से हम बहुत ही न्यूनतम मिले हैं और वो हमेशा इस बात की तारीफ करते हैं कि भाई आप इतने लंबे समय से राजनीति में हैं पर आपसे बात नहीं होती। कुछ बातें समझ में भी आती हैं। तो मित्रों, कोर्ट की प्रक्रिया सही ढंग से चले और हम यहाँ पर शब्द का प्रयोग कर रहे हैं मूट कोर्ट, और इसके अलावा उपभोक्ता संरक्षण कानून, ये बात तो बहुत अच्छी लगती है पर अभी इसके बारे में ये जानकारी नहीं मिलती है कि उपभोक्ता संरक्षण कानून से कितना लोगों को लाभ मिल रहा है। बहुत कम समझ में आता है। एक तो इस प्रक्रिया में लगता है कभी कभी देरी हो जाती है। हम उपभोक्ता संरक्षण कानून में न्याय की मांग करते हैं तो कभी कभी अब जल्दी फैसला हो ये हम सबको लगता है और फैसले का असर भी दिखाई दे, ये लोगों की समझ में आए कि फैसला होगा और इसका परिणाम हम सबकी समझ में आ रहा है। और ये विषय ऐसा है कि इतना लंबा विषय है कि हम देखते और सुनते हैं, जानकारी में आता है तो हमें लगता है कि उपभोक्ता संरक्षण कानून और आम आदमी को उसका लाभ मिले, ये बहुत आवश्यक है। ये ऐसा ना हो कि केवल चंद लोगों के बीच में इसका संरक्षण सीमित रह जाए और वास्तव में जिसको लाभ मिलना चाहिए उसको लाभ नहीं मिल पाए। इस पर बहुत सी बातें समझ में आती हैं, लोगों से बात भी करते हैं और जब हम कहते हैं कि इस काम के लिए आप कानून अगर है तो उसका लाभ उठाइए, पर कभी कभी लगता है कि दूसरे तरीके इस्तेमाल करके वो बात सामने नहीं आती है। यहाँ पर आप सभी नौजवान साथी उपस्थित हैं और अब हमें लगता है कि कानूनी प्रक्रिया में बदलाव हो रहा है। पिछले 20 वर्षों से हम जो देख रहे हैं, हम अपने जनपद में भी कोर्ट्स की प्रक्रिया देख रहे हैं और सारे बातें देख रहे हैं, पर हमें लगता ये है कि कानूनी प्रक्रिया का सही लाभ मिले और समय ज़्यादा ना लगे, जल्दी से जल्दी इसमें हमको रिलीफ मिले। अगर जल्दी रिलीफ मिलेगा तो निश्चित रूप से जिसको तकलीफ है वो तारीफ भी करेगा और पसंद भी करेगा कि हाँ वास्तव में अब प्रक्रिया में बदलाव हो गया है। और कभी कभी ऐसी व्यवस्था आ जाती है कि इतना समय लग जाता है कि संबंधित व्यक्ति जो प्रताड़ित हो रहा है, जिसे समस्या है, वो बहुत परेशान हो जाता है। फिर उसे लगता है कि कोई ना कोई तरीका निकाल कर समझौता हो जाए। तो हम कोई बहुत सारी बात कहने यहाँ पर आपके बीच में नहीं आए, और हमारा मानना है कि उपभोक्ता संरक्षण कानून जिस ढंग से काम करे और लोगों को समझ में भी आए, लोगों को लगे कि इस कानून का एक अच्छे ढंग से क्रियान्वयन हो रहा है और उसका लाभ भी मिल रहा है, ऐसा हम लोग महसूस करना चाहिए और हम लोग ये महसूस करें। आप सभी यहाँ पर मैं देख रहा हूँ अधिकांश नौजवान साथी हैं और एक लंबा समय आपके लिए अपने क्षेत्र में काम करने का अवसर मिलेगा। और मैं कचहरी अपने जनपद में जाता था, पर वकीलों से मिलता भी था, पर मुझे लगता यह है कि पिछले अब कुछ वर्षों में बदलाव आ रहा है। अब लोगों को लग रहा है कि कानून की पढ़ाई करना मायने रखता है। हम उस समय पढ़ते थे जब उत्तर प्रदेश के अंदर पढ़ाई का सिलसिला ही बदला हुआ था, इसलिए मैं उस समय की बात को यहाँ नहीं दोहराना चाहूँगा, पर अब बदलाव समझ में आ रहा है। अब नौजवान साथी ये मतलब कानून की प्रक्रिया में अच्छे ढंग से भाग ले रहे हैं और अच्छे स्तर के लोग भी आ रहे हैं। सबको लग रहा है कि अब ये ऐसा विषय हो गया है कि इसमें आने से हमको फायदा रहेगा, क्योंकि हमारे समय में लॉ की पढ़ाई वही करता था जिसको कोई काम नहीं करना होता। और पर जब से 3 साल का हुआ है तब से बदलाव हुआ है और ये समझ में आ रहा है। और जब जिस समय हम पढ़ते थे उस समय पूरा उत्तर प्रदेश मशहूर था कि नकल बहुत होती है, तो इसलिए पर अब बदलाव हो रहा है और हम ऐसा महसूस करते हैं कि अब कानून की प्रक्रिया में बदलाव, और अब नौजवान भी, लड़के और लड़कियां अच्छे ढंग से इस काम में बढ़कर आगे आ रहे हैं। अभी कल ही एक लड़की हमको मिलने आई, वो इतनी एक्टिव है, वो हम लंबे समय से जानते हैं उसे, कि वो बरेली में भी प्रैक्टिस करती है, लखनऊ में भी करती है और सुप्रीम कोर्ट में भी करती है। और कल यहाँ पर एक केस के सिलसिले में आई थी, तो हमसे मिलने आई थी। तो वास्तव में सोच अब समझ में आ रहा है कि बदलाव हो रहा है कि हम कैसे अच्छी पढ़ाई करें और पहचान बनाएं। और कानूनी प्रक्रिया में जाना मतलब हम दिल्ली में रहकर ये समझते हैं कि जैसे कोई हमसे कहता है कि अच्छे वकील से मिलवा दो, तो हम मना कर देते हैं। जैसे अच्छे डॉक्टर से मिलवाना हो तो डॉक्टर तो मिलते भी नहीं है, पर अच्छे वकील से मिलना भी आसान नहीं है। और दिल्ली में जिन वकीलों से हम संपर्क में रहे, अधिकांश वे वकील वे थे अरुण जेटली जी के अलावा जो कांग्रेस के थे। हमारी उनसे संपर्क बात होती थी, पर वो अच्छे ढंग से बात करते थे। और तब हमारी समझ में आता था कि वकालत प्रोफेशन दिल्ली में समझ में आता है कि कोई अहमियत रखता है, पर लोअर कोर्ट में जाने के बाद लगता यह है कि भाई भारी बदलाव की आवश्यकता है और इसमें परिवर्तन की बहुत आवश्यकता है। और इसके लिए ज़रूरी है कि जो वकील है वो खुद अपनी प्रतिष्ठा बनाने का काम करे। बाहर के लोग वकील की प्रतिष्ठा नहीं बनाते हैं, और अब इसकी आवश्यकता भी है। और हमारा मानना यह है कि हम कितने अच्छे ढंग से सामने वाले व्यक्ति को न्याय दिलवा सकें और उसको लाभ पहुंचा सकें। तो मैं कोई बहुत अधिक बोलने यहाँ पर खड़ा नहीं हुआ हूँ, पर हमारा मानना है कि मूट कोर्ट ये प्रक्रिया ऐसी है कि हम सबको समझ में भी आए और लोगों को महसूस हो कि अगर हम किसी काम की बात के सिलसिले में आगे जाना चाहते हैं तो जल्दी भी रिलीफ मिलेगा और कायदे का सही रिलीफ मिलेगा। मैं इसलिए कहता हूँ कि मैं खुद भी इसकी जानकारी करता रहता हूँ। तो एक मामले में हमने कहा कि भाई ये अगर लाभ नहीं मिल रहा है तो हमने कहा कि इसकी कानूनी प्रक्रिया अपनाई जाए। कानूनी प्रक्रिया अपनाने में जितना पैसा खर्च करना था, फीस के रूप में जमा करनी थी, हमने आवेदन करवाया और वहाँ पर जजमेंट ये हुआ कि साहब आपने जो फीस जमा कर दी है उतने की मान लेते हैं और आपका मामला ख़त्म कर देंगे। तो हमने कहा नहीं, हम तो ये चाहते हैं कि ये वापस हो हमें। तो उसके लिए भी हमको 2 साल और लगे। तो हमारा मानना है कि जो भी फैसला हो फैसला जल्दी हो और तुरंत हो और सामने वाले को लगे कि भाई वाकई में एक सही ढंग से न्याय मिला, उसका हमको लाभ मिल रहा है। तो मित्रों, हमें ध्यान है कि आज़ादी से पहले जितने देश की आज़ादी के इतिहास में लोग जुड़े थे, अधिकांश वे थे जो लॉ प्रोफेशन से अपने आप को जोड़े हुए थे, उसके हिसाब से काम करते थे। पर अब राजनीतिक क्षेत्र में बदलाव हो गया है और बदलाव देखते देखते हम महसूस करते हैं कि बदलाव बहुत हो गया। वैसे लोग राजनीति में आ रहे हैं अब जिनकी व्याख्या में करने का संदर्भ नहीं है, पर आवश्यकता है कि आप सब लोग जो यहाँ बैठे हैं, समाज को सही करके चलने की जिम्मेदारी हम आप सबकी है। कैसे समाज सही ढंग से काम करे और कैसे एक सही प्रकार से लोग जुड़े और हम उसको एक कायदे से न्याय दिलवा पाए। तो मैं इतना ही कह सकता हूँ कि भाई इस प्रोफेशन में आप लोग जहाँ हैं अपने सम्मान और प्रतिष्ठा बनाने का काम करिए और लोग महसूस करें, क्योंकि जब हम दिल्ली में हम लंबे समय रहे तो हम अक्सर वकीलों से मिलते थे कि लोग आते थे कि हमें अच्छा वकील दिखलाइए, मिलवा दीजिए। तो हम ऐसे वकीलों से मिले हैं कि हम कल्पना नहीं करते हैं कि ये कैसे वकील थे। एक स्वर्गवासी हो गए, दिल्ली में मशहूर वकील थे श्री पी.एन. लेखी। वो एक चुनाव हमारा लड़ाने आ गए थे, तब से हमारा संबंध हो गया। और मुझे ध्यान आया कि एक मामले में मैं उनसे मिलने गया, एक मामला पॉलिटिकल था इसलिए जाना पड़ गया, क्योंकि कोर्ट ने अदरवाइज फैसला दिया था, हाई कोर्ट ने, तो सुप्रीम कोर्ट में अपील करनी थी। तो उन पी.एन. लेखी साहब को जब हमने बताया कि हमने कहा विषय केवल इतना है कि सुप्रीम कोर्ट प्रभावित हो गया, हम हाई कोर्ट प्रभावित हो गया। अब वो ऐसा इतिहास था कि बताना ज़्यादा उचित नहीं है, पर लेखी साहब ने हमारी बात को समझ लिया और बोले ठीक है, बोले आप जो बात बता रहे हो पॉइंट सही है और इस पॉइंट पर केवल 1 मिनट ही बोलना पड़ेगा और रिट एक्सेप्ट हो जाएगी। और वैसा ही हुआ। पर मैंने महसूस करा कि वकील का ज्ञान, मैंने 1-1.5 घंटा उनको सारा विषय बताया, फिर उन्होंने अपने पीए को बिठाला, टाइपिस्ट को बिठाला और आधे घंटे में पूरा प्लान टाइप कर दिया। और जैसा वो हमको कह रहे थे, केवल मुश्किल से 2 मिनट बोले होंगे और तुरंत रिट एक्सेप्ट हो गई। तो वास्तव में वकील के बारे में हम अंदाजा ही लगा सकते हैं, किस ज्ञान के साथ वो काम करता है हम इसके बारे में कह सकते हैं। तो मैं दिल्ली में अक्सर कुछ वकीलों से जब हम रिक्वेस्ट करते थे कि आप केस को ले लें आप, तो एक वकील साहब हमको बोले कि बोले संतोष जी पैसे खर्च हो जाएंगे पर इनको रिलीफ नहीं मिलेगा। उन्होंने तुरंत वकील साहब ने हमको सीधे बता दिया और हमने कहा कि नहीं, अगला चाहता है कि उसके बारे में आप बात कर लें। यह 5-7 साल पहले की बात। तो उन्होंने अपने आप बताया कि इतना पैसा खर्च होगा और मैं जो बता रहा हूँ वो भी ज़्यादा सही है। और ये बात सही है कि वो जो कंप्लेंट की थी वो मतलब सुप्रीम कोर्ट के जज ने मुश्किल से आधा मिनट सुनी होगी और तुरंत रिजेक्ट कर दी। तो वकील की क्या कैपेसिटी है, क्या क्षमता है, ये इस बात पर निर्भर करता है। तो हम लोग जो यहाँ पर बैठे हैं, अगले को समझ में आया कि आपके पास आने से हमको न्याय मिल रहा है और सही मिल रहा है और सही जानकारी मिल रही है। आज ये बहुत आवश्यक है, क्योंकि डॉक्टर और वकील तो ऐसे स्थान है कि जहाँ पर आदमी जाता है तो समझता है कि उसको सही राय और सही जानकारी मिलेगी। तो मित्रों, कोई बहुत अधिक कहने हम यहाँ पर खड़े नहीं हुए हैं, और उसके साथ कि आप लोग जिस क्षेत्र में काम कर रहे हैं अपनी पहचान बनाएं और इस कोशिश में रहें कि जो व्यक्ति हमारे पास न्याय के लिए आ रहा है उसके महसूस हो कि हम पर भरोसा और विश्वास है कि भाई जिसके पास हम जा रहे हैं वो हमको धोखा तो नहीं दे। क्योंकि मैं चूँकि वकालत तो नहीं की पर मैं काफ़ी जाता था तो हमारे जो सीनियर वकील थे जिनके पास हम बैठते थे, एक बार एक केस को सुन लेने के बाद फिर वो दूसरे से उस केस के मामले में बात नहीं करते थे। वो कहते थे भाई इसमें हम बात कर चुके हैं, इसलिए हम अब आपके इस केस के बारे में बात नहीं करेंगे। ये वास्तव में न्याय प्रक्रिया में किस माहौल, किस संदर्भ में हमको काम करना चाहिए, ये हम सबकी समझ में आता है। आप सभी नौजवान साथी और यहाँ पर हम इस काम में लगे हैं, क्योंकि हमारा मानना ये है कि उपभोक्ता संरक्षण कानून एक बहुत ही महत्वपूर्ण संदर्भ है। हम आम व्यक्ति इसका लाभ उठा पाए, हमें ऐसा लगता है इसमें कहीं कमी है, क्योंकि कभी कभी इस प्रक्रिया में आदमी ऐसा फंस जाता है कि फिर वो सब पर नाराज होता है। तो मित्रों, मैं कोई अधिक बोलने या नहीं आया हूँ, मुझको कहा तो मैं यहाँ आपके बीच में हूँ, पर मेरा आप सभी से आग्रह है कि आप सब अपनी पहचान बनाइए, लोग महसूस करें कि वास्तव में अब इस प्रोफेशन में जो लोग हैं वो समाज और देश के लिए सही दिशा में काम कर रहे हैं और पहचान बढ़ाकर आगे काम कर रहे हैं। और जैसे हमारे देश के आदरणीय प्रधानमंत्री विकसित भारत और 2047 में भारत का स्वरूप क्या होगा इसकी बात कर रहे हैं, और जैसे उन्होंने कहा कि अब हमारा देश जल्दी ही दुनिया की तीसरी बड़ी आर्थिक ताकत होने जा रहा है, तो वास्तव में तभी संभव है कि हर क्षेत्र में हम सही ढंग से, सही प्रकार से काम कर रहे हैं। और उसके लिए एक क्षेत्र नहीं, सारे क्षेत्रों के साथ मिलकर रहकर काम करने की आवश्यकता है। तो मैं आप सबका आभार व्यक्त करते हुए, अधिक न बोलते हुए अपनी बात को यही समाप्त करता हूँ। बाकी यहाँ पर जो अन्य विद्वान लोग हैं वो आपको ज़्यादा जानकारी देंगे। आप सबका बहुत बहुत धन्यवाद। जय हिंद, जय भारत।
Extremely grateful for your kind words and your gracious presence today. Shri Anupam Mishra and Professor Dr. Ashok R. Patil to exchange the Memorandum of Understanding to establish the Consumer Chair on Research and Policy at NUSRL Ranchi. It gives me immense pleasure to mention that NUSRL Ranchi is the 4th university in the entire country to be bestowed with this prestigious chair. That all of us have eagerly awaited the announcement of results. May I request our Honorable Chief Guest, Shri Santosh Gangwar Sir, to kindly do the honors and recognize the outstanding performances of our participants. Institute of Law, Integrated Law Course, Faculty of Law, University of Delhi. The team is awarded with cash prize and trophy. Secondly, we have the prize for Best Memorial Opposite Party, which is again won by Team Quaffle, Integrated Law Course, Faculty of Law, University of Delhi. We now have the prize for Best Speaker, which is won by Ms. Bhumika Agarwal, Institute of Law, Nirmal University. The prize for runners-up is won by Team Titan, Law Center 2, Faculty of Law, University of Delhi. The winner is Team Sphinx, Institute of Law, Nirma University. Minister of Consumer Affairs, Food and Public Distribution, Government of India, Shri Joshi, on December 24, 2024, on National Consumer Day in New Delhi. The entire amount of their travel would be borne by us. The rest of the participants can kindly collect their certificates after the valedictory ceremony. I would now request Dr. Rabindra Kumar Pathak, Assistant Professor, National Law NUSRL Ranchi, to propose the vote of thanks for today's ceremony.
Very good afternoon to everyone present here. It is with immense gratitude and joy that I take this opportunity to extend the vote of thanks on behalf of National University of Study and Research in Law, Ranchi, and the Chair for Consumer Research and Policy. First and foremost, I wish to express our heartfelt gratitude to our Honorable Chief Guest, Shri Santosh Gangwar, Governor of Jharkhand, for gracing this occasion with his esteemed presence and inspiring words. Sir, your leadership and commitment to public service continue to inspire us all. Our special note of thanks to our guest of honor, Honorable Mr. Justice Sujit Narayan Prasad, and for having been a beacon for all aspiring legal professionals, especially in this university. We are profoundly grateful to Sri Anupam Mishra, Joint Secretary, Department of Consumer Affairs, Ministry of Consumer Affairs, Food and Public Distribution, for enlightening us with your perspective on consumer policy and law. Your support has been instrumental in the success of this competition. I also extend our gratitude to Sri Basant Kumar Goswami, Acting President, State Consumer Dispute Redressal Commission, Sri Bikram Hegde, Advocate on Record, Supreme Court of India, Sri Indrajit Sinha, Senior Advocate, High Court of Jharkhand, for judging the finals and for honoring us with their presence and sharing their profound knowledge and experience. I also extend our gratitude to Professor Dr. Ranveer Singh, Pro-Chancellor IILM Gurugram, for his presence in the inaugural and for having provided guidance for the conduction of this Moot Court competition. I would like to acknowledge our gratitude to Dr. Jagadish Halasetti and Dr. Ravindra A. Gunjale for their constant support in the smooth conduction of this event. I would like to acknowledge our gratitude to all judges who took out their precious time to judge the preliminary and the advanced rounds. Our sincere thanks to the Ministry of Consumer Affairs, Food and Public Distribution, Government of India, for their collaboration and encouragement in organizing this prestigious event. We deeply value your trust and support. I would like to acknowledge our Honorable Vice Chancellor, Professor Dr. Ashok R. Patil, for his visionary leadership and unwavering support in fostering academic excellence at NUSRL Ranchi. To all the dignitaries, faculty members, staff who have contributed tirelessly behind the scenes, Dr. Jisu Ketan Patnaik, Dr. Utkarsh Burma, Ms. Anushka Saxena, thank you for your dedication and hard work. To the participants, you are the heart and soul of this competition. Your passion, preparation and advocacy skills have set a benchmark for excellence. Congratulations to all the winners and participants for making this event so memorable. To the organizing teams, students and volunteers, your tireless efforts have ensured seamless execution of this event. Each one of you has played a vital role in making this National Moot Court Competition on Consumer Protection Laws 2024 a grand success. Finally, to everyone who joined us here today, Thank you for your time and presence. Your support and encouragement are invaluable to us. As we conclude this ceremony, we all carry forward the learnings and camaraderie of this event to achieve greater milestones. Wishing you all a wonderful evening ahead. Thank you.
This will be the beginning of many more milestones for NUSRL Ranchi. I would now request everyone to please rise for the national anthem.
पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगल दायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे।
I now request all the participants to please assemble near the stage for a group photo with the dignitary.
सब सामान ले लिया था राजू।
Thank you.